their time on my logs. Okay, we know that. I'm saying it over and over again. And put me in violation of Department of Transportation and company policy and everything else by doing so. And the fact that I went to the DOT, the Highway Patrol Office, talked to the Department of Transportation, said my logs appear to be altered. And I have a witness to that back in 2011. So we know that he did that. He falsified it. There's no doubt about it. I got a witness. I got a statement, and I should be working because I received a notice of offer of working on December 1st, 2010, and they held it up since October, supported by a QMA report that says I can do my customary duties, and that I have a permanent disability, and I was on FMLA, and I'm allowed prescription drug, which I was denied all of that. Okay, so on December 6th, he altered the logs. On December 7th, he just interrogated me without representation and just flat out sent me home. Didn't honor the notice of offer of work or FMLA. Okay, so I'm saying that they need to pay me back pay from December 7, 2010, 14 hours a day, because that's what I asked for in the notice of offer of work that I received on December 1st, 2010, and went to work on December 3rd, 2010, and on the 5th day, December 7th, 2010, they just flat out sent me home. Just flat out, just sent me home. They didn't honor anything. And the guy is the one that falsified my logs on December 6th, 2010, and he made a statement to that, to the fact that I was at work at 10:30, so I was on duty. And I should know that we bid every 6 months for a shift. Automatic start. So I was on that shift, automatic start from 10:30 in the morning. No matter what time I come in, the truck that he or tractor that he assigns me is going to start me off at 10:30, 11 o'clock, whatever. So I was on a 10:30 shift. So I was automatic start at 10:30 every day, no matter what time I come in. But my time was 10:30. I had to be there at 10:30. Okay, and so I was there. On the 10:30 shift, the dispatchers made that in a statement that I was there at 10:30 and that I punched in at 11:15, suggesting the fact that I punched in late. And I don't know how he figures that. I don't know how it can be late when I've been on duty according to my bid at 10:30 every day. Now, what that clock has to do, I don't know. But I know one thing. 11:15 or not, I wasn't late. I was doing my work, and I didn't attempt to falsify anything because of the fact that the data machine and the tractor or computer is tamper-proof. Tamper-proof. You can't falsify anything. Me or any truck driver in the United States that has a automatic onboard recording device 395.15 or 395.8 is unable to falsify anything. It's tamper-proof. So they need to pay me 14 hours a day plus interest. Plus interest. I'm asking for that. Because I've been off for a couple of years now. That's a long time. For them to come out to find out the truth of this whole thing. And now that my panel hearing was put into effect and that panel hearing was never finished, so it's on Mr. Nightwalker to finish that panel hearing. For the fact that they didn't send any registered mail. Mr. Nightwalker suggested to them that whatever my errors were, whatever I did wrong, they need to establish a fact beyond a reasonable doubt that I'm guilty by December 25th, 2010. Documents, photo, etc., etc. They didn't do so. They didn't respond 10, 20, or 30 days because Mr. Nightwalker sent them a letter to James Williams, Transportation Manager, to set a meeting for date and time, which was set for January 11, 2011. Was set for January 11, 2011. I should note that's more than 30 days. And according to the contract, they have to file agreements within 10 or 20 or 30 days from said act. And they have to prove it, according to Nightwalker, to send all documents by Christmas, December 25th, 2010. And they didn't do so. They didn't do anything. Okay? And they didn't put me back to work if they did not respond within the time limits. Okay? And they didn't complete step 1 and step 2. And they put everybody else to work, like 1,500 teams they didn't follow contract procedure, not one step. Okay? So he didn't put me back to work then, and they didn't honor the notice of offer of work for the FMLA, and I had a QME report to back it up, stating that I could do my customary duties, and that I'm allowed prescription drugs, which they didn't honor. And so they've been denying me 3 or 4 times, just continuously. And the union attorney sent a document saying that I was fired on December 16th, not December 7, 2010. And the fact that he sent a letter to the attorney and to myself stating I was fired on December 16, 2010, but he didn't mention one thing about it being denied on December 17, 2010, not one word. And he also didn't mention the fact that the dispatcher statement, okay, stating the fact that he changed or someone changed or dispatcher changed my logs from 10:30 to 11:15 would put me in violation with the Department of Transportation and violation of company policy and violation of contractual agreement made with Safeway and Local 439 in Stockton, California. Didn't mention one word about that the dispatcher accused me of falsification. He didn't mention a thing about the panel hearing that was put in abyss. Didn't mention the fact that his statement, the fact that 10:30 to 11:15 in the morning put me in violation. If I would have went out on December 7, 2010 in my tractor and I got stopped at the scales, the first thing the Department of Transportation is going to ask me, how did you get from point A to point B in that short amount of time? And I would have been wrote up. Okay? He put my livelihood at risk. It's worse than that. I'm unable to obtain employment by his said actions, by flat out altering my logs, okay, and then accuse me of attempt to falsify documents. Okay? So now we know. The meeting that was put into abyss needs to be completed by Mr. Nightwanger, so the truth can be known. And I can be returned to work because they didn't send any registered mail within 10, 20, or 30 days that they even filed a grievance to me or to the union, which is required under the contract. Okay, but if it happens to any other teamster there, that there's 1,500 teamsters employed at Safeway and Tracy Distribution Center, if they violate that contract within 10, 20, or 30 days, they're returned to work immediately. No questions asked. But I was denied that right under the contract. I was denied to be treated equally fair, just like everybody else. I guess because I have a permanent disability and I'm deaf. And the fact that I'm deaf, and they knew I had a hearing impairment from 2009 or before. And it wasn't acknowledged because I mentioned it to the shop steward and Mr. Nightwanger when the meeting was put in abyss, and I asked them if they were an authority on severe profound hearing impairment, and nothing was said, and I was just flat out sent home. Back to the attorney's letter, he left that out, okay? And the fact that he said he knew I had disability issues, it didn't matter. And the fact that I informed the attorney that I had a severe profound hearing impairment, it didn't matter. He said he's going to deny me arbitration, because they couldn't win the case, and I could pursue it under Workmen'S Comp if I wish to do so. Well, I wish to do so. Okay? So the fact that I had a severe hearing impairment, and the fact that the Judge Grill in the settlement conference hearing ordered the attorneys to give me a legal document that I'm deaf. And I went and took an examination from a panel from Workmen'S Comp, and had me sign a permanent disability that I was deaf, and that my hearing aids were old and broken. Okay? So I'm waiting for a document from my attorney. He's going to send a copy of that after he makes his report to my attorney, and I'm to receive a copy of that. So that the union, if they need a copy or they want to request a copy, they can have it. But they don't need it because the company never replied within 10 or 20 days. And they didn't establish a fact beyond a reasonable doubt that I was guilty or did anything wrong or falsified anything, when in fact the dispatcher did, and there's no doubt about it, and he admitted it in his statement on December 7, 2010. Okay, he admitted it. And I was there the whole day on December 7, work at least 3 or 4 times. Esperanza 417, Safeway Private Insurance Company in Arizona, denied me disability payments and medical treatment, etc., on 4/17/2009 behind a PR2 report that wasn't complete. I ended up in the hospital on 4/5/2009 and 4/6/2009. I took an MRI. And as you know that before that, on 3/21/2009, I saw Nancy Perdillo, who stated that it was a sprain, and she had somebody on the phone. She's a drug and alcohol technician, and I didn't see a doctor on arrival to the company's doctor in Tracy, California. Now, whether she sent me to the hospital or not, I don't know. And I never seen an occupational report made out. So I don't know. I'm not clear on that, but I am clear on the fact that she's the one that said it was a sprain. And I gave a copy of that on 4/6 to Dr. Hubby. I stand to be corrected, but I'm sure that I did. And she turned it into Safeway. And the hospital, Los Banos Memorial Hospital, made an occupational report out. And they suggested I go see Dr. Baby to get the pinched nerve or the pinched nerve that I have fixed. And it was denied by Safeway. Okay, because they sent the letter to Dr. Hubby to the wrong person when they should have sent it to Nancy Perdillo, because she's the one that said it was a sprain, even though she's not a doctor. Okay, Safeway sent Dr. Hubby a letter stating the fact that she said that it was a sprain, and that it's a low back and on-the-job injury, an industrial injury. Well, they sent the letter to the wrong person. So now on 4/17/2009, they suggested if I think I need an attorney, I should hire one, and I did. I hired Adam Stewart, and the fact that I filed for unemployment, and they sent me a letter back that stated that Safeway is in conflict of liability, or or something like that. Anyway, they said that they weren't allowed to decide anything. The EDD. Conflict of liability. Okay? So, anyway, that's what happened on 4/17. Now we're back to December 1st. This is 2013. And the panel hearing hasn't been finished yet, and the ball's in Mr. Nightwalker's court. So whether he wants to complete the panel hearing or not is upon him. And if the union attorney wants to refuse me arbitration on the fact that I have a severe hearing impairment, and I notified the two-shop steward, are you an authority on severe profound hearing impairment? And they just flat out sent me home. But Nightwalker did say he would discuss the issues or look into it with the company. But I've never heard a thing about anything since 2011, since we had the panel hearing. Okay? So I should know that I'm assuming that the dispatcher statement stating that I was there at 10:30 like I'm supposed to be, but I punched in at 11:15, and he's suggesting that I punched in late. When the bids are for 6 months, I bid for bid, it was a 10:30 start for 6 months, automatic. And my tractor starts me at 10:30 on duty automatically for 6 months until I change my bid. There's no way I could be late, and there's no way that because I didn't punch in, or I punched in at 11:15, that could be considered punching in late. Okay, I get paid by the laws in the tractor, and the tractor has an algorithm sheet which establishes the fact beyond the reasonable point that I was there on 10:30 doing my job. Okay, Sal and I got a workman's comp issue that the union attorney admits that I have a disability issue, and that if I wish to pursue it under workman's comp, I could do so, and I choose to do so. So the fact is that I'm sitting here and waiting for registered mail or a phone call to report to work, and it hasn't been done up to date. So whether the dispatcher on December 6, 2010 has the authority to falsify or alter documents, I don't know. Okay? But the fact is he did alter it, okay, and put me in violation of the Department of Transportation and company policy and contractual procedure. The dispatcher did that. He admits it on the statement on December 7, 2010 by stating that I was there at 10:30. And I don't remember the rest of the letter. And the letter, the union has a copy, local 439 in Stockton, California. And Safeway has the letter on file. So I'm sitting here waiting to be returned to work. Like I said, I took a hearing test, a panel hearing test for Workmen'S comp, and we're waiting a letter for that. So I'm asking for a court order to be paid back pay and benefits, 14 hours a day, 7 days a week, because it's a 24-hour operation. And I was hired in 2002, and I bought lifetime medical insurance. I gave them $3,000 plus, and they took that away from me on December 7, 2010, when they flat out sent me home. Nothing's been paid into it, so I needed to be made whole again. So I'm asking for a court order for the fact that they refused to put me to work at least 4 times. The last time, Esperanza was my claim adjuster, and they switched it to a Miss or Mrs. Morles, who's my new claim adjuster, and she sent me a letter stating when I signed a notice of offer of work that I didn't hand in on December 7, 2010, because they flat out sent me home. And on that notice of offer of work, I had 20 days to decide what shift I wanted, if I wanted the same location or whatever, and it's a legal document. I had 20 days to decide, but it was deemed accepted whether I decided or not. It was deemed accepted, and they took 15% out. Okay, I never started one day on the 10 o'clock shift. They never gave me that shift, and they took 15% out since December 7, 2010. Okay, and they held it up in the month of October. They held that notice of offer of work, I suppose, because it's dated October something, and I didn't receive it until December 1st, 2010. So I'm asking for a court order back base for 7 days a week, because I have 200 employees underneath me, and so I'm asking for 7 days, 14 hours a day, 7 days, and 7 days a week, okay? Anybody that works below me under the contract, I'm to be paid for that day, okay? And I'm asking for a court order to restore all my benefits and RSVP, lifetime medical insurance, which covers medical, prescription drug, hearing, Delta Dental, etc. Okay, and that's at 90%. And so, and I'm also asking, according to the 132A, I'm allowed a 15 or 1/3% increase. So I'm asking for the RSVP to be at 100%, if it's at all possible. So, following that, so I'm hoping Judge Bill considers the fact that the dispatcher falsified my documents, and there's no doubt about it, and the fact that the union said I could pursue it under Workmen'S comp, and also that the fact that he falsified my records and accused me and sent me home. He didn't tell the whole truth and nothing but the truth on his statement on December 7, 2010. And he didn't follow the contractual procedure and let me have representation. He told me that the shop steward is on his way, and now that I have a legal document that I'm deaf, which was ordered by Judge Brill, to get two attorneys to get me a legal document stating that I'm deaf. Okay, so I'm asking Judge Bill for those consideration for a court order for 14 hours a day, plus interest, and an RSVP and my health and welfare fund to be made whole, and the RSVP for lifetime medical to be made at 100%. And I'm still not back at work, and I'm still waiting for registered mail and a phone call. And today is Thursday, January 31st, 2013. So I'm asking Judge Bill to consider this, okay? There's no reason I should be returned to work, and there's no reason why I shouldn't get paid every day from December 7, 2010, 14 hours a day. Because I'm unable to obtain employment for the fact that the dispatcher altered my logs or falsified my documents, and the fact is I went to the Highway Patrol office and saw the DOT officer, and in front of a witness he stated that it appears that my logs have been tampered with, and where are the rest of the logs? They only gave me 5 days of logs when I should have had 7, so I know what my hours are available. It wasn't done. I was completely consider this, that a double standard is the application of different sets of principles for familiar situations or to different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of bias, morality, unfair suspension towards a certain group of the principle that all are equal in their freedom. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence, that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase life is not fair may be invoked in order to mollify concerns over double standards. I should note that I was born on 9/7/1940, September 7th, 1940. I'm 73 years old, and I've been hired at Safeway in 2002. And like before I said, there's almost 200 people underneath me in seniority. Okay, and I had a notice of offer of work, and I'm asking for it to be enforced from December 7, 2010. And that the notice of offer of work, according to the QME report, which is supported the notice of offer of work, that I can do my customary duties. And that I'm allowed prescription drug, and I was on FMLA. So I'm asking the notice of offer of work to be enforced by Judge Grill, and that to consider my statement and putting me back to work. And I also invoke double standards. Life is not fair, for the record, okay? So this is Julio Zamora, 1385 El Camino Way, Los Banos, California, Class 1 truck driver, OTR. I hope Judge Bill considers this, and again, I invoke double standards. Life is not fair. I'd like to know one thing. The dispatcher, he's working, and I'm not. He just flat out sent me home, or had me sent home. And I also like to note that the PR2 report wasn't signed first and last name by the doctor or myself, which is required. And I also like to bring up the fact that I wasn't paid every week or every 2 weeks from 4/17 on. Okay? And I also like to note the fact that I'm asking Judge Grill to retire me automatic retirement on September 7, 2013. Automatic retirement. Okay, whether I like it or not, with a letter from the personnel to be informed, to send me a letter stating that I retired from Safeway with a permanent disability. Because I can't work there any longer after all this. I've been off work a couple of years, going on 3 years, been off work. And I didn't do anything wrong. So I like it to let it be known that I'm innocent and that I be returned to work so I can clear my name and get my lifetime medical. And the fact that I have 2 children in the university, one's in the Air Force, and my daughter only needs 1 more year. That's all she needs is 1 more year to get her BA degree in biology, chemist. So it's my life is on the line here, okay? And so I'm asking Judge Bill to consider that. And again, that I be automatically retired on September 7, 2013. And that I be made whole and my RSVP be increased to 100% lifetime medical for life. And a document stating that I'm going to have lifetime medical for life at 100% with a document stating that, making that statement from the personnel department at Safeway and Tracy Distribution Center in California, or the private insurance company Safeway for Mr. or Mrs. MORLES. So, and I should also bring out the fact that the notice of offer of work was good for 1 year. I was guaranteed 1 year of work. I was guaranteed 1 year of work, which I was denied. And I didn't work 1 day on a 10 o'clock shift Eureka run. And they took out 15%. Okay? So this is Julio Zamora. I invoke double standards. Life is not fair. This person took my time card or my log sheet or drip sheet or whatever, and everything is thrown in the garbage because I didn't get paid for that day. And he's working and I'm not.
I should note one thing, that there's no reason why they shouldn't call me back to work, either a phone call or registered mail, when they realize that the dispatcher altered my documents. So there's no excuse for them not calling me or giving me a phone call. It's a 24-hour operation. So I just thought I'd throw that in there.